It is for everyone. You don't want to not do an estate plan and have things turn out poorly.
We also have an old saying that if you don't have a plan, the state of Florida has a plan for you. And you may not like that plan.
So starting it off early can help you in the long run and protect your legacy.
Hi, everybody. Welcome to Chimes Dimes, brought to you by First Wealth and Trust of Winter Garden. I'm Pete Baksh, the Chief Investment Officer here at First Wealth and Trust, and I'm joined today by Harry Hackney, who's of counsel for Merideth, Nagel, PA, and Legacy Legal Team. And we've got Alice Taft, who's a trust officer at First Wealth and Trust. We want to thank the Winter Garden Heritage Foundation for allowing us to film in this space. The mission of the Winter Garden Heritage Foundation is to preserve and celebrate the rich history of West Orange County while fostering innovative cultural experiences. The stuff on these walls speaks to generations of history in this area, and it's really exciting to be broadcasting from here. They aim to connect our community with its past while inspiring future generations to shape a vibrant, culturally rich future. In this episode, we're going to be discussing some of the common pitfalls of improper estate planning and how to avoid them. So before we delve into our topic, Harry, could you say a few words and introduce yourself to our audience?
Sure. Be happy to. And thank me for having me here today, Pete. And Alice, thank you for inviting me. I've been practicing law for 39 years, 40 years this coming October. And during that time period, I've practiced at every level of the state court system, from county court all the way up to the Florida Supreme Court. And mainly what I've done is litigation of one type or another. More and more the last probably going on 2 decades now, it's been litigation related to guardianships, trust estates, probate, and that sort of thing.
Thank you. And Alice, maybe say a few words about yourself?
Yes, I'm a certified trust and fiduciary advisor and accredited estate planner. So I kind of help those attorneys like Harry with people that want to tell their whole story to me, and I put it in a form to get the attorney to draft their documents. And we do all of the administration at First Wealth and Trust. And as you know, Pete does the investment side of that.
Well, thank you. And yeah, so I'm in charge of our investment team, whereas they structure and make sure everything's legally correct in the estate plan, hopefully, or, fix it if it's not. Which we probably will hear some stories about later. And the actual plan that gets hammered out, I'm the person, my team helps us get from where we are now to make sure we get to accomplish all the goals in the estate planning process through investments. And with that, I think we're ready to jump off and get started. I would like to start, before we get into perils of improper planning, let's talk maybe a little bit and give the viewers an idea of what proper planning is going to look like or sound like, and who it's for. Maybe with you, Harry?
Thanks. First of all, the time to do your estate planning is before you need it. Because what we see frequently, somebody will come in and they'll say, my mom, my dad, my grandmother, they need a power of attorney. And I'll say, great. Why are you calling me? Oh, well, dad's, really out of it. He's in a nursing home, or grandma, I'm like, well, then I'm sorry, I can't help you. And well, what do you mean? Well, if they're too incapacitated to pick up the phone and call a lawyer, they're probably too incapacitated to also do their estate planning or to give you a power of attorney. Somebody has to be competent in order to delegate their rights and abilities to somebody else. And if they're not competent, they can't do that. So you want to do your estate planning when you're competent. We also have an old saying that if you don't have a plan, the state of Florida has a plan for you. Mm-hmm. And you may not like that plan. That's called intestacy if you die without an estate plan. And what happens then is things get very medieval. And in some cases, you might have stepchildren. Your stepchildren are completely not included in your estate plan if you die intestate. And in fact, if somebody takes advantage of you and they unduly influence you to cut your stepchildren out of your estate planning, even if you intended that they be included, they'll be cut out, because unless they were in a previous estate plan, they don't even have standing to contest it because they're not your intestate heirs. So those are all things you have to keep in mind.
Perfect. And maybe the question, I'll move this over to you, Alice. Who is it for? I think there are a lot of misconceptions out there that, you need to be way up here on terms of wealth or standing in order to have estate planning, when really it's probably something to my knowledge is good for everybody to do.
Right. Yes. That's one of the main things people tell me is I don't have enough money for a trust. Well, it's not just about how much money you have. You might have, the house, and you might have family heirlooms. You might have, and you're going to grow, hopefully your assets will grow. So starting it off early can help you in the long run and protect your legacy. So it is for everyone. And you don't want to not do an estate plan and have things turn out poorly. I think that's just what you don't want to have happen. And if you have that, at least get a will, at least that way the judge will know what you want done. So yeah, it's for everybody.
Sure. Okay. Well, thank you. So kind of now that we've established that this is really something for everyone, what does something, let's get a ballpark idea of what something like this might cost, a range, obviously, from the legal perspective?
Well, it's going to depend on the scope of the services involved. A will typically is going to be less expensive than a trust. Wills are shorter. They're less involved. A typical will might be 3 or 4 pages. A trust might be, anything from 10 pages to 50 pages, depending upon how complex you want to get in terms of the way things are handled. A lot of estate planning is done on a flat fee basis. So when you come and talk to a lawyer, they will quote his or her fee that they normally charge for example, his and hers wills or an individual will. If you come in for a trust, likewise, depending again on the scope of what you want to do, because you at the end of the day are the client and the boss, they will either quote a flat rate or, may in some cases do it on an hourly basis. It just depends on the circumstances. I think it's also important when you're talking about it's not just for people with money. Estate planning also isn't just for dying, because when you come and talk to a lawyer about estate planning, they're not just going to do a will or a trust. They're going to do a durable power of attorney. They're going to do a healthcare surrogate, which is a medical power of attorney. They're going to probably do a living will. I do a pre-need guardianship form that you file in local circuit court. And if anybody ever files to be your guardian, the clerk of the court goes and looks in their index of individuals who have done these pre-need guardianship forms and then notifies the judge that, well, Homer said he wants Marge to be his guardian. This petition was filed by, Lisa.
Oh, yeah.
So, there's a number of documents and discussions that involve not only your death, but during your lifetime, how will things be managed if you're not able to do them for yourself?
And then from our perspective,
well, like if they name us as a corporate trustee, we don't charge anything until we start managing the assets. So you can name us in your trust and it can sit for years until we're ready to manage. And a lot of times we'll put that in our vaults at the bank. So we have it on hand. And so there's really no charge there for us. If we start administering the trust because you become incompetent or death, then we do charge a percentage of assets under management.
And can you give me a ballpark idea what that is?
Generally, it's 1%. I mean, obviously, percentages change over time, so I can't say for sure. If you watch this podcast in 10 years, it's going to be that. So
fair enough. So I think, basically we can establish it's going to vary based on the complexity of the situation, really.
Yeah, I will say that 1% is probably less than the cost of litigation in many cases.
Sure.
Sure. Well, you alluded to this, Harry, about how important it was to clearly identify the beneficiaries. That's the next kind of question we had up. Can you give some insight, maybe a situation where this has come up that you can recall?
There's what we call testamentary capacity. And it's a relatively low bar, but one of the requirements of testamentary capacity is that you know who the natural objects of your bounty are. Now, people tend to think, oh, your kids. Maybe, maybe not. You can have natural objects of your bounty that are not your children. And a classic example, an elderly woman that lived in the neighborhood behind the office I was in at that time passed away. A friend of hers, who's actually the gentleman that developed the subdivision where she lived, came to us and said, this friend of mine has passed away. She has nobody locally. I want to start a probate estate on her behalf. She has this, her only living relatives are this niece that lives out in Texas, and she's got this nephew that she's estranged from. Nobody's even sure where the nephew is. He was thinking that her assets go to the niece and nephew of her late husband. They were not related to her by blood. She was an Italian war bride and had moved to the U.S. shortly after World War II. And this was less than 10 years ago. So she'd lived in the U.S. for many years. And it ended up that her estate went to about 11 Italians and one Swede.
Wow.
That had probably never met the woman in their lives. So they inherited about, $400,000 or $500,000 in assets, plus her house, which was another $300,000 in assets. Went to people who, like I said, she had probably never met, didn't know who they were. And one of them kept threatening to call the Italian police on us because we wanted to send him money. And his share ended up going to the state of Florida because he would not accept a check from us.
Wow.
For her assets. I had a lawyer write us a letter saying he was going to have the Italian police after us. And we're like, bring them on.
I think they might lack jurisdiction.
They might. Yes. Yeah. We were not real worried.
Can you think of any stories on our end, Alice? I know we've dealt with a lot of complicated situations.
Yes, we have a lot of complicated trusts, and beneficiaries aren't always happy with what they are going to receive. And at being a corporate trustee, we have to go by what the trust document says, and unfortunately, sometimes that's not what they want. We have a lot of difficulties from time to time. I've had one recently that had personal property and no one could agree on who could get what. So I sat them all down and they drew straws and they chose that way. I mean, it's just, you never know. Some get along and some do not.
Yeah. Imagine that was an interesting meeting.
Yes.
So what about if they weren't happy with your method of assigning, assets, the drawing of straws, and nobody could come to an agreement? At this point, does this get escalated to litigation, or, how does that work?
Yeah, it's certainly something you could take back to court if they're willing to pay that price.
And most likely, I think what would happen is one of the beneficiaries would probably be the one to go hire a lawyer. Mm-hmm. And actually, at the end of the day, they'd probably end up in the same place because that's a fairly common method for breaking those deadlocks. Yeah. The judge has the exact same problem. They're constrained by the law. They're constrained by the terms of the trust. And if you've got a bunch of people saying, I will accept nothing but, grandpa's favorite bowling ball and nothing else, and I've got to have these 5 things. It's kind of like the scene in The Jerk. All I need is this bottle of water and this cup and that megaphone. That's all I need. And if you get that kind of a deadlock, the judge has no better way to decide it either. So he's going to do it by lottery.
Interesting.
And the point is, you don't want just one family member handling all that for your family, because that becomes the bad guy. And so a corporate trustee is the best way to go, because we don't care who wants what.
The more litigation I get involved in, the more frequently I'm like, I just wish they'd hired somebody neutral to begin with, because it's a lot harder to accuse a corporate trustee of, you're just doing this because I stole your dolly when you were 3. But with family members, frequently they look at everything through the lens of their, 50-year history and their sibling rivalries. And, I used to do family law, and I tell people the happiest day of my life was the day I quit doing family law. And they'll go, well, what about when your children were born? What about when your wife you got married? And I've been married for 40 years. And I'll say, you don't understand. And then people will say, but isn't probate litigation a lot like family law? And I'm like, yeah, but it's kind of amusing watching people in their 60s and 70s work out their children rivalries, their childhood rivalries. And that's what a lot of probate litigation comes down to. And hiring a professional takes that out of it, because, they didn't share a bedroom with Alice. But they shared a bedroom with their older brother who's telling them no now.
So this dovetails onto a point that I don't think is clear to the general public, or at least many of them, the difference between probate and having a professional corporate trustee. It might be worth taking a couple of minutes here and describing what those differences are.
Yeah, a corporate trustee on the probate side, can be the personal representative. And so we go through the court process with an attorney involved. So, they pay extra for that too. So if you can avoid the probate, that's the best way to go.
And let me interrupt for just a second. So avoiding probate is good because, my understanding is that's putting it in the hands of the legal system, the Florida law and the judge to interpret what goes where versus the trust. You've carved everything out.
Right.
Not exactly.
Okay.
Probate, if you die intestate without any kind of a will, you'll end up in probate. You'll also end up in probate if you die with only a will. And the judge doesn't decide. Either the intestacy statute says who gets what. Okay. So it's not the judge. The intestacy statute says, and like I said, it's very medieval. It's all bloodlines. So if you die and you're survived by 3 children, each one of your 3 children will get an equal share in most cases. If you have stepchildren, they may be left out completely, even though you were very close to those stepchildren, regard them as your own children. They may not get anything because you died intestate. Might go to, like in the case of the Italian war bride, it may very likely go to people you've never even met or don't know.
Sure.
So that's the probate process is legal and in court, but it's constrained by the terms of your will or by the intestacy statute. The trust, likewise, the trust avoids probate because the trust is a separate legal entity apart from the person who died. So the trust has a life beyond the person who established the trust, which we call the settlor or the grantor. So the trust continues to exist after their death. And because the trustee then has the beneficial ownership of the property in the trust for the benefit of the beneficiaries, the trustee can manage it without having to resort to court because the trust already owns all the assets if you've properly funded it, which is very important and very frequently not done properly.
100% true.
But it's key to avoiding probate.
So this sounds like a natural launch into the next question. How is that trust funded to a sense where it's proper and you're going to avoid those issues?
And those, that's where we help the client fund their trust by naming their assets in the name of their trust. So any bank accounts that they may have, they might want that in the name of the trust or at least payable on death to the trust. The deeds, the attorney does that as part of the estate plan. So it's a matter of making sure you're retitling your assets so that your trust is fully funded. And you would be surprised how many are not that I see. I'm like, well, what'd you get the trust for if you're not going to fund it?
Well, if, for example, you have an investment account and your investment account is owned by Homer Simpson, you're Homer Simpson.
Okay.
If you form a trust and you want the trust to deal with your investment account when you die, you have to change the name of your trust to Homer Simpson as trustee of the Homer Simpson Revocable Living Trust. And that tells the world that the trust owns that account and will continue to own the account even after Homer Simpson dies. And then the owner of the account would become, depending on who you've chosen as your successor trustee, Marge Simpson as trustee as the Homer Simpson Revocable Living Trust.
Or perhaps First Wealth and Trust,
yes,
if you've named a corporate trustee.
Exactly. And for the record, I've never seen one episode of The Simpsons.
Oh. They predict the future, don't they?
They do.
From what I understand, pretty scarily accurately. And so now let's jump into the purpose that we came together today to talk about some of these horror stories that are potentially out there for doing it the wrong way. We've talked about some of the ways we can get it right. We did hear a bit about the wrong way with your story just a little while ago with the Italian police and whatnot. But let's hear some more because I think people need to understand the gravity of this. What could possibly go wrong?
It's not just doing estate planning wrong. I mean, a lot of it's not doing any estate planning at all. The kind of thing I see happen all the time is, first of all, don't underestimate the propensity of your children to fight with each other. Particularly if you have a family with big gaps in age. I tend to see a lot of litigation that involves, you might have 2 or 3 children that you had early in life, and then you had another child 15 years later. And that younger child did not grow up in the same family as the older children. Frequently, it's that younger child that doesn't feel the connection to the older children you think they do. The youngest daughter picks your nursing home. well, it's the youngest daughter that's picking the nursing home and in mom's ear about, they don't count. I'm the one here. I'm the one helping you. You don't need them. And you get what we call undue influence in instances like that. I've seen more and more, I've become convinced that trusting your own spouse too much is a bad idea. And giving him or her what we call a power of appointment or a withdrawal right. Because lately I've seen cases where the surviving spouse, I had one recently. The husband died. He had an investment. He had his own trust. His trust treated his children equally. He died. Daughter moved in on mom, convinced mom that, the son who owned his own electrical company, et cetera, was ne'er-do-well. Actually, it was a plumbing company. Now that I think about it, but owned his own plumbing company, was ne'er-do-well, and you needed to not leave him everything. And mom went and withdrew all of the assets from dad's trust and moved them into mom's trust, and then changed her estate planning so it primarily benefited the daughter over the son. And dad died with his own trust, believing that his millions of dollars in assets would go to son and daughter equally. And that's not what happened. Daughter changed the estate planning, moved all those assets out of dad's trust into mom's trust. I've seen that happen before where, my clients, they weren't real nice guys, to be honest with you. It was dad's second wife that was not their mom. When dad died, according to her son, they called her up and cussed her out and said, "Where's our money?" She went down to the bank, took all of dad's assets out of dad's trust account and moved them all into her trust account. Same thing. And they said, well, she had a power of withdrawal. She could do that. So I think you have to be more circumspect about things like giving complete control to your spouse, allowing them to revoke and amend the trust after your death. More and more, I'm convinced the right way to handle it is two separate trusts, and yours becomes absolutely irrevocable upon your death. And if the spouse has any power of withdrawal at all, it's very limited.
I see.
Yes, those are great ideas there.
So from our perspective, I know, and I know we see a lot too. Are there anything we can do, protect the names of the innocent and so forth?
Yeah, I was trying to think of some stories without saying too much, but it's kind of hard. But the main thing is, if you got a corporate trustee in it, you're not going to have all those same problems, and that's the crux of it. So
let me know what happens in a situation like that. Say that situation that you just mentioned, you've got and after the fact, a spouse is trying to adjust a trust after the fact.
If she has legal right to do so.
Yeah, but I mean, with the bank, so the bank in that sense, or the trust company, or whoever that corporate trustee is, can't do much, which brings us all back to this thing has to be set up correctly to begin with, because the corporate trustee is not going to have the leeway.
Chances are there's not going to be a corporate trustee in that scenario. Right. Chances are they had a joint trust.
Oh, yeah.
And the wife or husband, either spouse, had the unfettered right to revoke or amend that trust. And then they'll go and they'll use that ability to revoke or amend the trust, either revoke it or amend it to do something that their spouse never contemplated in a million years would happen after their death.
Yeah.
Unintended results. That's just part of the estate planning world.
Yeah. So, I mean, I think that basically covers what we came to talk about today. Are there any final parting words that either of you would have?
I could tell you stories like that all day long. And twice on Sundays.
Well, thanks to the both of you for coming on, and thanks to everybody out there watching. Remember, investments, estate planning, things of this nature are complicated. They're tailored to an individual. So don't take this episode as personalized advice. If you have questions, reach out to a legal team, reach out to First Wealth and Trust, and come see us. We love to talk about this stuff. Thanks for joining us. And, if you like this podcast, hit like and subscribe, share with your friends. And we look forward to the next time we see you.
I'm a lawyer, but I'm not your lawyer.